Thank you. Thank you. Dignitaries from around the globe, speakers, participants, organizers of this event, ladies and gentlemen. I was surprised to be invited to this event. I'm not a technician, and I'm not a regulator. But when the wise Giovanni Butrelli spoke to me, incidentally, today was the first time I ever saw him, I realized that what he intended out of me was a presentation of an Asian perspective. Does Asia and India follow in the footsteps of where the world is going on digital ethics? The old adage that knowledge is power has stark implications for the individual who accesses data for the power of knowledge. Data is ubiquitous in today's life. It has become imperative to rely on data in almost all actions, events, processes, and decisions. The process of accessing data commences the very moment you leave your house just to find out how the traffic would span out on the different routes you can take to your destination. But you must understand that if you access data, somebody knows. And the day could well end on the data platform, finding out the best place to go out to dinner, given your individual food preferences and location. And this too is known. Individuals send emails and use instant messaging services to interact with family, friends, and even for formal communications. Online banking has evolved in a big way. Sale and purchase activities are increasingly being carried out through credit and debit cards. Online trading has created a new platform even for the market in securities. If you or a loved one is unwell, the doctor's diagnosis is understood completely from internet data. And if you are traveling, instead of the old-fashioned travel agent, the internet gets for you the best possible deals. Online booking, online music, online books, online movies, and a whole host of matters of individual interest are now available without any difficulty. Today's life is therefore most wonderful and most definitely data-driven. At home, at work, and even for all that goes on in between and after. But be very sure that somebody knows every time you access data. Every time the individual accesses a site on the web, he leaves behind electronic tracks. Just simple access to data could have a whole lot of implications, making it important to understand how and from where the data has been collected, where and under whose control it is retained, and what is the nature and kind of data accessed. In the background of today's life being more and more data-driven, it is necessary to understand how data entities can or could impact individuals accessing data. This would lead us to an understanding of the realities about data-driven technology and whether it is or will serve mankind, and also who benefits and who does not from the data-driven technology. Data in the Internet of Things have the ability to redefine human existence in ways which have yet to be fully understood. The challenges which data poses to privacy interests extends from state and non-state actors. Data and internet are emerging as a new tool for surveillance. The concerns of intervention are now not only personal issues of privacy, but also extend to the very vulnerability of national integrity and security. Digital technology in recent times is believed to have had the force and wherewithal to interfere even with the democratic processes of independent nations, and so also on the issue of defense and national security. Privacy at the level of the individual extends to the preservation of personal liberty and dignity, and privacy at the level of independent nations extends to the integrity, sovereignty, and autonomy of every individual state. The means of use and misuse of data in the case of individuals and in the case of nations is just the same. In most matters, what happens at the micro level in the case of individuals is manifested at the macro level in the case of nations, something in line to what Sir Tim Berners-Lee had said in his presentation prior to lunch. Therefore, understanding the issue at the micro level can lead to its understanding at the macro level. As the position stands today, only the enforceable and legally protected rights of the individual recognized as constituting the individual's zone of privacy can be legally protected. Privacy postulates the reservation of private space in which an individual has the right to be left alone. The notion of privacy recognizes an individual's control over personal interest matters as control over personal honor and extending to matters pertaining to his body and mind. A space forbidden to everyone without the individual's leave, express or implied. It is necessary to keep in mind that an individual's right to be left alone cannot be understood in a manner as would pervade into the rights of privacy of others. Privacy in that zone of an individual's right, which is free from societal compulsions and also from societal expectations. Since individual privacy does not intrude into societal obligations, other individuals are likewise entitled to live their own private lives without intrusion. Similarly, nations have individual rights, which likewise need to be protected to the extent that they do not transgress into the rights of other nations. The Supreme Court of India in 2017 held that personal privacy constituted a fundamental right under the Indian Constitution. And when I was introduced just now, that seems to be the basis of my invitation here. I need to tell you that in the 80s, there was a judgment by the Supreme Court, a constitution bench of the Supreme Court with 8 judges, which said that privacy was not a defined fundamental right. And then in 2017, a 9 judges bench turned around to say, no, privacy is a fundamental right under the Constitution. Now, how does this happen? Let me take you back to what Giovanni Butrelli and Anita Allen said. They spoke about ethics. And when we talk about ethics, it becomes difficult to understand whether ethics can be enforced. But that's exactly what happened in India. We have Article 21, which talks about the right to life and liberty. And it was these ethical standards that were incorporated into the right to life and liberty, which made privacy a part of the right to life and liberty, and therefore a fundamental right of the citizens of the country. Based on the decision of the Supreme Court, the Indian Parliament tabled the Personal Data Protection Bill 2018. This legislation aims at creating appropriate relationship of trust between individuals on the one hand and entities possessing their personal data on the other, and for specifying the rights of individuals whose personal data is to be processed. This is what the speakers during the morning had said. The enactment through Section 5 mandates that personal data would only be processed for purposes which are clear, specific, and lawful. Again, something that was said in the morning. But here is a legislation which is coming in force. The legislation also expressly, through Section 4, casts a duty on entities processing personal data, requiring them to process such data in a fair and reasonable manner, which would respect the privacy of the data principle. To achieve the above legislative objective, an attempt has been made to create a framework for implementing organizational and technical measures, including the prescription of norms for cross-border transfer of data. An attempt has been made to ensure accountability of entities processing data and also provide remedies for unauthorized and harmful use of personal data. Data protection has recently been a subject of animated debate in India. This discussion arose as a result of a recent legislation. They call it the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act 2016, requiring unique identification for all residents in India through Aadhaar numbers. Aadhaar numbers were mandated to be provided to residents on the basis of their demographic and biometric details. The Aadhaar numbers was meant to serve as the individual's universal proof of identity. A legal challenge was raised to this legislation on a variety of grounds, amongst others, that the legislation had the architecture of pervasive surveillance and that the enactment violated the individual's personal right to liberty. In fact, an argument was raised that Aadhaar numbers could be used to cause the civil death of an individual. And how does that happen? If your bank account works on the Aadhaar number and your salary comes to you from an Aadhaar number, and if your mobile phone is based on the Aadhaar number, all that you need to do is disconnect the Aadhaar number. And you can't access your bank, you can't get your salary, you can't have a mobile phone, and you can have nothing. So all these arguments were raised, and there was intervention by the Supreme Court recently on the 26th of September 2018. And quite a few measures in this legislation were set aside. It was held that enrollment of Aadhaar could only be voluntary, and on consent, information gathered during enrollment or authentication could not be shared for any reason whatsoever, except on the approval of a district judge. It was also held that enrollment of children would require the guardian's consent, which could be revoked on attaining majority. And further that, school admissions could not require Aadhaar identification. The court also directed that the Aadhaar Act be amended so as to allow individuals or victims whose rights had been allegedly violated to file a complaint and initiate proceedings. Retention of data up to 2 + 5 years per regulations 26 and 27 were held to be excessive and accordingly set aside, with the direction that the provision be amended to reduce the period to 6 months. The unqualified adoption of Aadhaar identification by the state, by a body corporate, or by any other person was struck down as not satisfying the proportionality test. Aadhaar linkage to the bank accounts under the Prevention of Money Laundering Act 2002 was held to be unsustainable. It was also held that every bank account holder could not be targeted under the garb of money laundering or black money. The same was accordingly set aside. Linkage of mobile connections with Aadhaar identification was also struck down as not sustainable. This sums up the legal position as it stands in India. At the moment, all that can be said is that the digital divide is real. It has advantages and disadvantages. Its implications are global and individual, therefore vast as well as narrow. We have started to enjoy the benefits of digital technology. We have also started to understand the dangers associated therewith. Governments and courts have started to deal with them. We cannot be complacent, lest the damage causes a ruination which becomes difficult to redress. We need to ensure that data-driven life continues to benefit individuals and nations, and thereby plays a positive role in the service of mankind. Ladies and gentlemen, I thank you very much for your time and your patience. I would also like to thank the organizers, especially Gulvani Butrali and all those people who were associating themselves with me and making it comfortable for me to come here. Thank you very much. Thank you all.
Thank you. Thank you, Chief Justice. Please, let's take a seat here. A number of questions that have come in via the conference app from the audience. Maybe we could start with the first one here. Has the Cambridge Analytica scandal had echoes in India?
Yes, very much. And I suppose the breaking ground will happen in the United Kingdom. There are political connotations, and when there are politics involved, it always takes time. But there is going to be a repercussion in view of the law that has been settled.
Is there a debate on big data and electoral campaigns?
Well, it has always been a debate in India that elections could be changed and driven by data and technology. And recently what has happened in a very powerful country makes it very clear that outside nations can interfere in the electoral processes of other nations. And that's a big challenge.
And finally, how is fairness applied in India in the context of technology?
Just as I said when I was making my presentation, ethics, which is fairness, had no role expressed or implied in the fundamental rights. But over the years, constitutions which are always growing and changing and interpreted differently will depend on the will expressed by the people, and you will then reconfigure your judgments by the latest thought. And when the latest thought in India, after 40 years, from the 80s to last year, 2016, 2017, after privacy was declared as not a fundamental right, but then ethics, which is not the whole of ethics, but ethics which is the natural human right of every individual that sustains in him and cannot be taken away from him, has to constitute a part of his life and liberty. And that's how the Supreme Court has interpreted it.
Thank you very much, Chief Justice.
Thank you.